again, so we're on Plessy versus Ferguson. And what we just saw was the Louisiana law said in order to be legally white, you could only be 1/64th white. Or, excuse me, only 1/64th black. Went to the Supreme Court. This case went all the way to the Supreme Court. And this is what the Supreme Court said in a judicial activist decision, the worst of its kind, alongside a number of other cases which we talked about. We were talking about judicial activism. They said separate but equal facilities were constitutional. Remember, this is the Supreme Court. Because if one race be inferior to the other socially, the Constitution, meaning the 14th Amendment, the Constitution cannot put them on the same plane. Now, if you take what the Supreme Court says here and rephrase it in terms that we phrased it with respect to the issue, when we talked about constitutional interpretation, what they're in essence saying is this. They're saying the 14th Amendment. So as a reminder, this is the 14th Amendment. So what they're saying is that the 14th Amendment is itself unconstitutional. Never mind that the 14th Amendment says no state shall make or enforce any law which shall abridge the privilege or immunities of citizens of the United States, nor shall deprive any person of life, liberty, property, due process of law. Never mind that. They're saying it doesn't matter that it says this, because if a race is inferior to one socially, the Constitution, by its language, cannot put them on the same plane. So they said, in essence, they said the 14th Amendment is unconstitutional. What they're really saying, what they're really admitting to, was the Supreme Court was being activist. And you can see here why there is a serious problem when the court decides to be activist. So, in essence, again, the court reiterated that Equal Protection Clause guaranteed political but not social equality. This is a private railroad car. The state could allow that to happen. So, what then does the Black Civil Rights Movement do? But before they get to what the Black Civil Rights Movement does, you have a couple of other cases that reveal that Plessy is just a lie. What happened in Cumming versus Richmond County Board of Education was after Plessy versus Ferguson, the Richmond County Board of Education decided it would close down the black high school, saying that black students, because the schools were segregated, black students could always go to private schools. No, they couldn't. They couldn't afford it. This was so close after the end of slavery. Blacks, most of them were still tenant sharecroppers. There was no way they could afford a private school. So what the court was, they were giving their stamp of approval to segregation. And you see this kind of invidious discrimination, this hatred against blacks. And the reason it has taken our country so long to get over slavery is because of that once we ended the institution, that predominantly in the South, you had this kind of institutional racism against blacks. And so Cumming versus Richmond County Board of Education, what I want you to understand for the test, it revealed that Plessy was a lie. Because they didn't care. They didn't care that there was no black high school, only a white high school. They said blacks could always go to private school, and the reality is, no, they couldn't. They just couldn't afford it. So this is when the Black Civil Rights Movement decided that they would use this two-pronged approach. They realized that to try and change the reality of what people thought in the institutions of Congress and state legislatures, that's what people thought. That's the people they voted in. So they decided they would use the courts. All they needed was a majority of 9 men. And so the NAACP, which was an organization, National Association for the Advancement of Colored People, which was started after a race riot, decided that they would seek to reverse Plessy versus Ferguson. Well, how do you do that? How do you seek to reverse this racist decision? Interestingly enough, the NAACP decides that they're going to ask the court to enforce Plessy versus Ferguson. Now, if you go back to the judicial doctrine of the decision, it said separate but equal facilities. You could separate the races as long as they were equal. And so what the court did, what Black Civil Rights Movement decided to do is they would test this idea. They would use this as a judicial doctrine and say, yes, these facilities are separate, but they are not equal. So they looked for cases, and this was a slow, painfully slow process, but they would look for cases where it was blatantly obvious that it was unequal. Yes, they were separate all over the place, but they wanted something that was blatantly obvious that it was unequal. Then once they got some of those, then they'd go a little less obvious, until a little more subtle. And they would move through trying to reverse Plessy versus Ferguson this way and achieve equal civil rights. So the first case is here in 1938. Now, you get what I mean. So Plessy versus Ferguson is decided in 1896. So 42 years later, they have their first case where they have some success. And that is Gaines versus Missouri. So what's going on in Gaines versus Missouri? This was a case in which the state of Missouri had a white law school, but there was no black law school. And in essence, the Black Civil Rights Movements, their attorneys asked this simple question: does 0 equal 1? Does no black law school, 0 black law schools, equal 1 white law school? And the answer is obviously no. Now, in 1938, not a lot of people wanted to be lawyers. And so lawyers didn't make the kind of money they made in the 80s and 90s. And, of course, there's lawyers that make big money today, but not all lawyers make big money today. And so the idea from the Black Civil Rights Movement was, so what if a few blacks become attorneys? Nobody's going to really pay attention. Nobody's really going to worry. This was one of those things where there was something obviously unequal, and the feeling was nobody would care. And the Supreme Court agreed. They agreed. And they said 0 does not equal 1. Either build a black law school or let the blacks in the white law school. And so, of course, they had to let the blacks in the white law school. That was their first test case. So they had to be admitted. Next case, Sopel versus Oklahoma. So Oklahoma could read the writing on the wall. Same kind of case as Gaines versus Missouri from 1938. Yes, 1938. But again, a decade later, 10 years later. And so Oklahoma, to deal with this issue, the fact that they had no black law schools, they said, okay, we're going to plan one and we're going to build one. Well, it had been a while. And so the NAACP asked the question, does a future 1, or we could say F1, equal P1? F being future, P being present. F, there's 0. So in the variable, we could make it look like this. So, future 1, right now it's 0. So 0 times 1 equals 0. Whoops, that should say. Sorry. So does a future, and we don't have one right now, so that's 0. Does 0, even though they're planning one in the future, equal 1? And the answer is obviously no. So again, the court said the same thing. Let the blacks in to the white law school. You got to admit them now. So you see this slow, painfully slow process. It's been 52 years since Plessy versus Ferguson, and we've got a couple wins. Sweatt versus Texas. They realized, okay, we've had these 2 other cases. We're going to have to let blacks into our law school, our white law school. But what they did, they still wanted to separate the races. So they admitted them into the school, but they imposed boundaries. This boundary amounted to a painted line on sidewalks throughout the school. Blacks were to remain on one side, whites were to remain on the other side. But the reality is, everybody knew that the reason you had the painted line was to keep the blacks, quote, in their place on their side. What about the library? What do you do about the library? If you know anything about library research, and most students don't today, but at the time, that's all there was. when you go to the library to do a research, oftentimes what you find is serendipitously. You go up there to find something, you find a book that you think is going to be on point for what you want, and then what you find in the stacks of books are other books that you didn't know about that talk about the subject and maybe more on point to what you want. But for blacks, all they could do where the library was concerned was go down into the basement of the library, go to a clerk at a desk and say, I want a book that deals with this, and the library would go get a book, but they didn't have the opportunity to look and see what else was there. And even if they had, if you impose this arbitrary limit that they've got to stay on one side and white's got to stay on the other side, when everybody knows it's really just to keep the blacks in place, that is invidious discrimination that works to their harm and their detriment. So the court said, no, you can't do that. They've got to have equal opportunity, equal access. And they said, get rid of the line. So you see this slow process. And finally then, in 1954, you're looking at 58 years after Plessy versus Ferguson, there is a case that the NAACP thinks they can use to end segregation in public education throughout the South. Now, there is a problem. There's a problem, and there's a disagreement within the NAACP. The disagreement is there was a segment of the NAACP that felt, wait a second, we're going too far too fast. If we stretch here and miss the mark, it could be that the High Court, meaning the Supreme Court, will reaffirm Plessy if we fail. Others felt that they should go for it, they should take their chances, and end this plight, and they felt that this was a moment in history that they could do that. And we will pick up there with the next video.